Judgment in the matter of FamilyMart China Holding Co. and Ting Chuan.
This appeal from the Cayman Islands to the Judicial Committee of the Privy Council was the first of the 3 cases which are being handed down today. It was the first to be determined, but the decision was not promulgated until the summer recess because it overlapped with the decision of the United Kingdom Supreme Court in the Republic of Mozambique appeal, which I have just described. The appeal raises the question of the basis on which legal proceedings may be stayed to allow the parties to determine their disputes in accordance with their contract to arbitrate. The relevant legislation is the Foreign Arbitral Awards Enforcement Act. This Act, in Section 4, provides that if a party to an arbitration agreement commences legal proceedings against another party in respect of a matter which has been agreed to be referred to arbitration, the other party may apply for a stay, and the court must grant a stay of the legal proceedings unless it is satisfied that the agreement is inoperative. This provision, like Section 9 of the 1996 Act in English law, gives effect to the New York Convention, and the Board again draws on international jurisprudence from other contracting states in determining this appeal and in addressing what is a matter and what is meant by inoperative in Section 4. The dispute is concerned with the breakdown of relations in a joint venture company between a Chinese corporate group and a Japanese corporate group, which operates a large convenience store chain in the People's Republic of China under the FamilyMart brand, which was developed elsewhere in East Asia by the Japanese group. The joint venture operates through a Cayman Island registered holding company. The Chinese group are the majority shareholders, and the Japanese group, which brought the brand and the know-how in running large convenience stores into the joint venture, are the minority shareholders, holding just over 40% of the shares. The relationship between the company's shareholders is governed by a shareholders' agreement. That agreement contains an arbitration agreement which provides that any disputes in connection with or arising out of the shareholders' agreement are to be submitted to arbitration under the ICCA Rules in Beijing. The Japanese shareholder, whom I will call FMCH, presented a petition in the Cayman Islands for the winding up of the holding company on the ground that it was just and equitable to do so. This was based on alleged misconduct in the management of the business by the Chinese majority shareholder, whom I will call Ting Chuan, including the diversion of profits to other companies associated with Ting Chuan. FMCH does not intend to seek the winding up of the holding company, but under Cayman Island company law, it can obtain a share buyout order, which it seeks, only if it presents a winding up petition on the just and equitable ground, and the court, satisfied that it is just and equitable to wind up the company, exercises its discretion by making an order as an alternative to making the winding up order. Ting Chuan applied for a stay of the winding up proceedings in order to have their dispute determined by arbitration. The Grand Court of the Cayman Islands granted a stay until the underlying matters had been arbitrated. FMCH appealed, and the Court of Appeal overturned the decision on the basis that no part of a winding up petition was susceptible to arbitration, but was the exclusive preserve of the courts of law. The Board unanimously allows Ting Chuan's appeal. In relation to the meaning of matter, the Board holds first that the Court adopts a two-stage test. The first stage is to identify the matter or matters which the parties have raised or may foreseeably raise in the court proceedings. The second stage is to determine, in relation to each matter, whether it falls within the scope of the arbitration agreement. This involves ascertaining the substance of the disputes without being overly respectful to the parties' pleadings and having regard to defences that are reasonably foreseeable. Secondly, a matter need not encompass the whole of the dispute between the parties. Although not expressly stated in the Cayman Act, the Board holds that the Act, in common with international jurisprudence, provides for a stay to be granted in respect of part of the proceedings. Thirdly, a matter is a substantial issue which is legally relevant to a claim or a defence which is susceptible to be determined by an arbitrator as a discrete dispute rather than an issue which is peripheral or tangential. If the matter is not an essential element of the claim or of a relevant defence, it's not a matter in respect of which legal proceedings are brought. And fourthly, the test entails a matter of judgment and the application of common sense. It's not to be applied mechanistically. This approach may sometimes lead to the fragmentation of parties' disputes, but effective case management should mitigate the adverse effects of such fragmentation. In relation to the meaning of the word inoperative, the Board recognises that international consensus in the common law world, that the power to wind up a company lies within the exclusive jurisdiction of the courts, as such orders affect third parties and there is a public element at stake. But an application to wind up a company on the just and equitable ground may involve matters in dispute, such as allegations of breaches of a shareholder agreement, which can be referred to an arbitral tribunal because they are essentially a dispute between the two contracting parties. Applying those rulings to the facts of this case, the Board holds that the disputes as to whether FMCH has lost trust and confidence in Ting Chuan and its management of the company, and as to whether the parties' relationship has broken down irretrievably, disputes which lie at the heart of the overall dispute between the parties are disputes which are arbitrable. On the other hand, the decisions whether it is just and equitable to wind up the company, and if so, whether to make a winding up order or to order a buyout of shares as FMCH seeks, are matters within the exclusive jurisdiction of the court. The Board therefore grants a stay of the winding up proceedings in relation to the two arbitral matters, and grants a discretionary stay in relation to the company under Section 95(1)(d) of the Companies Act. The Board will now adjourn.